Um, Thank you for attending IMT's fourth webinar of our Better Buildings for Everyone series. Our final one for the summer is titled Legal Pathways for Building Performance and Decarbonization. And we're joined today by some great speakers from the Public Health Law Clinic. So my name is Rajiv Ravalapati. I use he, him pronouns. I am the government engagement lead for IMT. I'm based in St. Louis, Missouri, and we are going to be hearing from several staff attorneys today from the Public Health Law Center based in Minneapolis, Minnesota, also known as PHLC. We've got Dani Replogle, who is a staff attorney based in St. Paul. We're joined by Daniel Carpenter-Gold, another staff attorney who is based in Long Beach, California. Apologies for that typo there, Daniel. And then finally, we're joined by senior staff attorney, Jamie Long, who's also based in Minneapolis today. So just as a quick recap, again, this is our fourth webinar in our series on Better Buildings for Everyone. Earlier this year, we held a couple different webinars on BPS implementation and what it takes to implement a BPS, talking about high performance building hubs back in March, federal funding and financing of BPS, and the kind of grant levers that are available for jurisdictions and how they're approaching all this wave of federal dollars. And then today we'll be talking about those legal pathways for building performance and decarbonization. And we're going to take a pause for the summer and then come back later this fall to talk about some community engagement opportunities with a BPS. Now, before we begin, just a quick couple housekeeping notes. We will have someone monitoring our chat. We'll have our presenters go through their full presentation, but if you do have questions that you would like to pose, go ahead and throw them in the chat, and we'll also be throwing in some resource links to supplement each of our speakers' topics and areas of discussion. So before we begin, we kind of want to just get familiar with all of you, and we're going to drop in two poll questions to answer for you guys to answer. One, very simple, what industry are you in? So let us know if you're a building owner, you work for a local government, you're a nonprofit. So just take about 5 to 10 seconds to answer that one. And let's go ahead and see those results. Great, looks like we've got mostly local governments in the house, which is great. We love to see everyone else from the service provider community, from the nonprofits. If you marked yourself as other, if you don't mind, let us know who you are and what you're representing today. And then our second question is just to get a familiarity of your current understanding and level of understanding with building performance and decarbonization policy. So we'll go ahead and throw that that poll question up. So again, just answer, what's your current level of understanding of building performance and decarbonization within your state or your local government? So just take another about 5 seconds to answer that, and we'll take a look at those results and we'll jump right in. Well, great. So it looks like most of you are familiar with a BPS, are familiar with some kind of building performance or decarbonization policy goals. And there's a low amount of you with a low understanding. But that said, today's webinar will give you a lot more of a comprehensive understanding of the kind of things that are going around the country, as well as those legal pathways to help local governments and state governments navigate to these policy objectives that you have within your locality. So our agenda today is what you see right in front of you. And what you'll hear in today's webinar is that our presenters from the Public Health Law Center, also known as PHLC, will be talking about the available pathways for jurisdictions to pursue building electrification. So, why building decarbonization policies? They'll be going through a couple of different flavors in terms of the emission regulations, building energy performance standards, codes, and gas distribution curtailments. So this webinar will give you guys an ample opportunity to ask our presenters jurisdiction-specific questions. So again, you can throw in questions into the chat, but we'll also have a dedicated Q&A discussion after our presenters speak today. So why building? So to start, as we know, the current rate of updating buildings with energy efficiency just simply will not meet climate or resilience goals laid out by communities, by state and local governments. There are certain policy levers that are needed to prioritize and act on energy efficiency so that betters the performance of those buildings, also more so than just buildings, because we see buildings as an opportunity to improve people's lives, but it betters the performance of those buildings for its people, for the grid, and for our greenhouse gas reduction goals. On those statistics that you see there on the slide, we know that codes regulate the minimum standard of how buildings should be designed and built, but what about all those existing buildings? In 20 years, 2/3 of the buildings that exist today will still exist. And those are the buildings in which we occupy, the ones that we work in, the ones that we play in, the ones that we live in. Yet we're seeing that in that second categorization of building points, the current pace of major energy efficiency improvements annually is very low, about 2% from commercial buildings and then less than 1% for residential buildings. So again, the rate of updating these buildings with energy efficiency is really important, particularly for those communities and those governments that are working together on trying to meet their climate and resilience goals. So I'm going to pass it on now to our first speaker today, Dani with PHLC. Take it away, Dani.
Thanks, Rajiv. So yeah, as Rajiv said, we are the Public Health Law Center, and we are a team of attorneys, policy analysts, and support staff working to address public health through the power of law. And as you'll see on your screen, we offer free legal technical assistance to communities and public health advocates, including local governments and nonprofits. And we have extensive experience providing trainings, webinars, and general information on legal topics. But two important things to remember, just that when you're contacting us, we do not directly represent clients in litigation, and we also do not lobby. Next slide, please. Yeah, so we've talked a little bit about why electrification policy is important, but there is one major tool that the gas industry and other opponents have been using to counter electrification policies, and that is preemption. Preemption is the legal doctrine that allows higher levels of government to limit authority of lower levels of government to regulate in particular areas. And states can preempt local policies. So there are currently 21 states with preemption clauses that limit the power of local governments to pass more stringent building codes than that the state has enacted. And there are a handful of states that have proposed language to the same effect. And then federal law can also preempt state and local action. And there are two particularly relevant federal laws that I'm going to be talking about today. The first is the Energy Policy and Conservation Act. Next slide. Okay, so just a little bit of background. The Energy and Policy and Conservation Act has been a hot point of discussion recently, at least among us environmental law nerds, and that is because of a recent Ninth Circuit opinion from a case that the California Restaurants Association brought against the city of Berkeley. And so in that case, the Restaurant Association alleged that the preemption clause in EPCA, the Energy Policy and Conservation Act, preempted Berkeley's ability to pass an ordinance that would prohibit many new buildings from connecting to the gas utility service line. And it's been kind of known as, this is what we've been hearing as a gas ban. And the Ninth Circuit recently held in favor of the California Restaurants Association because Berkeley's ordinance concerned the energy use that the appliance is covered by EPCA. So energy use is kind of the key word there. And so there are a number of issues that legal scholars have with that Berkeley opinion. And Berkeley has also submitted a petition for rehearing. So it's very possible that within the next few months that the outcome will change. But for now, the Ninth Circuit decision is causing some concern. So the rest of our presentation is going to focus on how to develop strong policies that can stand up to preemption challenges while still achieving all of our emission reduction goals. And so on the screen, you'll see that I'm going to be talking about regulating emissions. This is an approach that is a step removed from regulating energy use, which again is the kind of fundamental issue in EPCA. And so when you get away from that, it's a little bit less likely that this will be seeing the same treatment as Berkeley's ordinance. And then the other reason that we might regulate emissions rather than energy use is because it more directly targets the problem of climate change, and jurisdictions might like that for constituency reasons. And these policies can also be plugged in really easily to any existing emission reduction goals. And so the first kind of flavor of emissions regulation that I'm going to talk about is fuel standards. Fuel standards are ostensibly regulating the quality of the fuel that's being used as opposed to the use of that fuel. So not saying you can't use gas, just regulating the type of gas or the quality of the gas that you're allowed to use. And so an example of a fuel standard would be the language that you're seeing from New York City. And that standard prohibits people from burning any fuel that emits 25 kilograms of carbon dioxide equivalents per million BTU of energy in most buildings. And so that standard effectively bans fossil fuel combustion because not even so-called clean gas can meet that standard. So just kind of a point of interest is that New York City's ordinance also includes an exemption for combustion that doesn't connect to a building supply line. So theoretically, people could be bringing their own gas tanks into buildings and still use their appliances that are covered by EPCA. So you're just kind of putting some obstacles in the way, but it might be less of a preemption risk. Next slide. The second flavor of emissions regulation that we see is under the Clean Air Act. So under the Clean Air Act, states have really broad authority to implement and maintain air quality standards. And the primary tool that they use for this is called a State Implementation Plan, or a SIP. And this is where states lay out their emissions limits, and SIPs under the statute have to include criteria pollutants, which are the 6 listed in that little blue box. However, the Clean Air Act gives authority to states to regulate other pollutants as well. But the kind of nice thing about a SIP is that because it's mandated under the Clean Air Act, the SIPs get federal, they have the power of federal law, which brings them on par with the Energy Policy and Conservation Act. And we see courts abiding by this rule that they try to interpret federal laws in harmony with one another. And so it's possible that by putting an emissions limit in your SIP, you're giving it, you're elevating it to the same level as EPCA and giving it another layer of protection against the preemption issues that we've seen in Berkeley. Now, unfortunately, you'll see that the criteria pollution list doesn't include carbon dioxide or any of the common greenhouse gases that we are familiar with. And there was a petition to make carbon dioxide and carbon dioxide equivalents criteria pollutants, but that was denied during the Trump administration. So the kind of good thing about that is that some of the criteria pollutants, in particular the nitrogen oxides and particulate matter are also byproducts of fossil fuel combustion. So you can kind of get at those greenhouse gases by way of limiting those other pollutants as well. But it's unlikely that or at least according to EPA's interpretation, other non-criteria pollutants that are included in a state SIP probably won't get the same protection from EPCA as the criteria pollutant limits that are in those plans. Next slide. And the last emissions regulation that I'll talk about really briefly, because I think everyone here is familiar, would be building performance standards. So really quickly, building performance standards are a policy that set increasingly stringent standards over time. There's lots of different metrics that a jurisdiction could use in their standard. For example, my colleague Jamie is going to talk about energy use emissions. Daniel's going to talk about energy use and energy efficiency standards. And you can also potentially set a health-based standard, but the ones that we're interested in for the purposes of my portion of this talk are emissions. So let's look at some examples. The first example would be Boston's Building Emissions Reduction and Disclosure Ordinance. And you'll see the kind of standard, it's setting per square foot per year. There's a limit on the emissions of carbon dioxide equivalents. And then the other really important piece is these alternative compliance pathways. So in Boston, you can, in addition to meeting that emissions standard, you can purchase renewable energy credits. You could install renewable capacity, or kind of last resort, you could pay a fine. So we're seeing these alternative pathways that encourage electrification, but don't necessarily require it in the same way that a gas ban or so-called gas ban would. Another example is Seattle. You'll see that they've got 3 different paths. The first path would be kind of similar to that first route under Boston, just meeting all of the emissions requirements. The second path provides some exemptions and reduced requirements for certain end uses based on, and also an alternative compliance payment. And then there's also the option for Path C, which is an individualized compliance plan. And so that is an attractive policy because it offers self-election for building owners to give them a sense of agency. And finally, we have Ithaca, which is sort of the gold standard at this time as far as a building emissions performance standard goes. And they have 2 different compliance pathways, the whole building path, which takes advantage of the many green building certifications that are already in existence. So that's one way that you can comply with their BEPS. And the second would be the easy path, which is that owners have to accumulate a certain number of points by various deadlines. And those points are earned by various energy efficiency, decarbonization measures, some of which involve electrification and some of which do not. And with that, and knowing that we have more time for questions later, I will pass it to my colleague, Daniel.
Thanks so much, Dani. So Dani just talked about the regulation of building and fuel emissions. And as she mentioned, I'm going to talk a little bit about regulating energy use. And so this is closer to the core of federal preemption under EPCA, but there are still a couple of policies that are possible and are being used to reduce energy use in buildings directly. Specifically, the ones that I'm going to talk about today are building energy performance standards, which are like the BPSs that Dani was talking about, but regulate energy instead of emissions. And also efforts to pare back gas distribution infrastructure, which is, at least to me, a very interesting approach that targets both electrification and the negative impacts of electrification from having all of these stranded assets that potentially gas customers could be paying for. But first, I want to talk briefly about how these regulations are helpful given EPCA preemption. So as discussed by Dani, EPCA has been understood to preempt energy efficiency standards for appliances. That's the core, what I'm thinking of as the core of EPCA preemption. The recent Berkeley decision, if it stands, could expand this to preempt building level restrictions on gas use and probably bans on gas appliances generally. So the two policies that I'm talking about today, and the reason that we're highlighting these is that they could avoid this. First, neither of them deal with energy efficiency of appliances. Again, that's the core of federal EPCA preemption. And then while building energy performance standards do target energy efficiency, they don't do that at the appliance level. They do that at the building level. So there's still room to have appliances that meet the federal efficiency standards within and don't have to go below it within the scope of these policies. Second, for gas curtailment policies, gas distribution curtailment policies, they do target a specific type of fuel, which is potentially put in play by the Berkeley decision, but it does so at a higher level, broader level, at the neighborhood or street level, rather than the level of individual building. And there's elements of the Berkeley opinion that suggest that that might be okay. So with that established, I want to talk briefly about a couple of building energy performance standards in more detail. So again, I'll skim through this a little bit because I think folks are very familiar with building performance standards generally, and Dani just discussed the emissions side of these. So these are like the building energy performance standards are like building emission standards in that they target a certain level of energy efficiency and potentially and continue to decrease that level of energy efficiency over time. They also so as mentioned, they address energy use instead of emissions, and they generally address energy intensity, so that's energy per square foot per year. There's a couple of important policy elements that distinguish it from emissions-based standards that I want to highlight here. The energy performance standards, first of all, they don't care about the type of energy used, just the amount of energy. And so in that sense, it's very different from an emissions-based standard because you can do things like use natural gas, as long as the natural gas is being used in an efficient manner. And there's some differences in the level of efficiency that is achievable with different fuel types, but as a general matter, it's fuel agnostic. Second, they don't completely eliminate energy use in the way that emissions-based standards can theoretically eliminate emissions. Instead, they select an energy use target for each building type using a percentile value from a baseline year. That is, they choose an existing energy efficiency level that's achieved by that building type and then require underachievers in terms of energy efficiency to meet that. So if you go to the next slide, please, there's a chart that just shows the hypothetical scenario based on large multifamily homes in St. Louis, where you could this is just to illustrate the idea that outliers are being brought down to a level of energy efficiency that's already achieved in the initial baseline year of measurement, and that some buildings could theoretically stay at the same level of efficiency or even slightly increase and still be in compliance. So let's look at a couple of specific examples. So here I'm going to be talking about St. Louis and DC, which are very prominent building energy performance standards. Both of them have the characteristics that I discussed before. They target existing achieved building energy efficiencies. In St. Louis, it's the 35th percentile, so 65% of the buildings in the baseline year would need to decrease. In DC, it's the median, so half of the buildings would need to decrease. DC has a couple of interesting alternative compliance elements that I think are worth highlighting. So both allow a reduction in terms of the energy use of the specific buildings, although DC allows this on a permanent basis and St. Louis focuses this on the initial kind of catch-up period. And then DC also allows implement a measures-based compliance, so allows buildings to take individual actions to reduce their energy use intensity. And those actions have to target a level of energy efficiency achievement, but they don't actually have to achieve it as long as the measures are implemented. And so that's allows building owners to hedge against the possibility that the measures are not as effective as they had thought. Both allow credit for initial large reductions in energy use intensity. And then a final point that I want to highlight here is that both have expanded timelines or options to expand the timeline for affordable housing and certain other building types. Affordable housing is particularly difficult in the building decarbonization space because they're very tight in terms of financing, and it's often very difficult to do large retrofits that need to be financed in between affordable housing cycles. And so one measure of alternative compliance or a little bit looser approach to that building type is to allow them to have a longer cycle so that they eventually achieve that level of emissions reduction, energy use reduction, but they do so over a longer period of time, which hopefully fits better in their financing cycle. So with that very brief overview out of the way, I want to talk about gas distribution. First, a quick overview of what gas distribution is. So this is from the EIA as an overview of the whole life cycle of natural gas use. We're talking about just the tail end of that. And that's moving natural gas from the city gate point, the high volume transmission lines, to individual homes and ultimately to individual appliances. Next slide, please. So gas distribution is accomplished primarily by a network of larger pipes running under public rights-of-way called distribution mains. And they, then service lines that come off of those mains. On the left, you have a sort of stylized diagram of what that looks like. And then on the right, you have an example from Alameda, California, of an actual natural gas network. And the important thing for thinking about how gas distribution curtailment could work is to understand that these networks all exist in these different sub-networks that you can see in different colors on the right. And the idea is that these sub-networks, or even points within them, can themselves be reduced so that the physical infrastructure that goes into this, the physical natural gas lines that are running under the streets, don't have to be repaired and replaced at high cost to the gas utility, a cost that is ultimately borne by gas customers. So in other words, these networks can be trimmed and cost savings can be achieved through that. So how does this look? This is a fairly new field, at least as far as I understand it, in terms of intentionally electrifying and then curtailing existing gas distribution networks. The existing approach, demonstrated by the image on the right here, is to, when there's a single customer or a small number of customers that are at a remove from the rest of the gas network, is to try to get them to electrify, and then you can save a lot of money by not replacing that long or not maintaining essentially, or replacing the long pipe that leads to that. But electrification, this sort of what California calls tactical decommissioning, is more like the image at the bottom, where you have maybe a street of buildings that are in a denser network that you can, from an infrastructure perspective, remove the gas pipeline from. And as long as the buildings there are willing to go fully electric. And the idea for electrification of these buildings is that in California's case, the State Energy Commission, the utility, the gas and the electric utility, if they're separate, and local governments and sometimes local organizations work together to plan out a process for electrifying those buildings. This allows the benefits of electrification while also preventing the potential high cost of unmanaged transition from gas to electricity, whereby the fixed costs, or the cost of maintaining all those physical infrastructure, gets the burden of that gets placed on an ever diminishing group of customers. One last point that I want to make before we transition is that as currently understood, this is a voluntary process. So PG&E, the utility that is working on this particular pilot program, has said that they don't think that they have the authority to withdraw gas supply so long as any customer still wants to use it. And so the process is, there's some talk about at the state level removing that requirement. But as currently understood and is currently implemented, this is a fully voluntary process where people are agreeing to electrify their individual buildings. And with that, I'll turn things over to Jamie to talk about the next stage.
Thanks so much, Daniel. So you've heard from my colleagues about local and state policies targeting emissions and energy use. And now I'll be talking a little bit about building codes and how that interacts with EPCA, Energy Policy and Conservation Act, and federal preemption. Next slide. So we have talked a little bit about EPCA, but just to talk specifically about how this applies in the building code space. So EPCA preempts state or local energy efficiency or energy use standards for covered products. So think about gas furnaces or water heaters. And for EPCA at the federal level right now, it meets federal standards to have gas-fired appliances. So when you hear EPCA compliant or federally compliant, you should be thinking gas appliances. So under EPCA, there is a specific exemption for building codes. And there are 7 criteria that a building code has to meet in order to be exempt from this preemption. But I'm not going to walk through all 7. I'm just going to highlight 3 that are most talked about and probably most relevant for local jurisdictions that are thinking about these. So the first is that a building code cannot require that a covered product exceed EPCA standards. So you couldn't just say all installations need to be electric, for example, under this approach. The second is allows products exceeding EPCA standards to comply on a 1-for-1 energy basis. So if you do have a product that is going to be more efficient, it should be getting credit somewhere else for exceeding those federal standards. The third is if codes allow multiple ways to meet energy objectives, at least one option must include covered products that do not exceed EPCA standards. So there has to be at least one ability to install, in this case, gas appliances. If a local jurisdiction is meeting these 7 criteria, it does not need to do anything else. It doesn't need to apply to the Department of Energy. There is also a waiver process under EPCA to the Department of Energy for unusual and compelling state or local interests. And we won't be going through that waiver process today. But once you have met those criteria, then the question is, does a court agree that you have satisfied EPCA? And there have been 2 cases so far that have been litigated where somebody is challenging a local government that believes that they've met this 7 criteria EPCA test. The first was in 2008 in Albuquerque, and the Albuquerque code had both a prescriptive option for HVAC and water heating appliances that went above federal standards, so that would be not EPCA compliant. And then it also had 4 performance-based compliance options. So it had a LEED Silver, a state-based green building certification, an overall 30% energy reduction, or a standard reference design. So the court was analyzing whether these performance-based compliance options were preempted or complied with EPCA. The court did find that there was EPCA preemption, and they found this because when they were looking at these compliance pathways, they found that if a builder was going to be using a product that was above federal standards, then they would also have to take extra requirements to be able to meet that performance criteria. So, for example, they would have to, if a jurisdiction was using a EPCA compliant product, then they would have to take additional steps. So, for example, they'd have to caulk or seal doors. And so this was an added cost for those individual builders, and the court found that penalized using federally compliant products, and that this, in a sense, effectively required the use of products above federal standards. Next slide. The second court case was from 2012, and this was looking at Washington State's building code at the time, and it set a 15% reduction target in new building energy consumption from a baseline and set out 3 different compliance options. 2 of those options allowed builders to earn extra credits through alternative energy reduction approaches, such as envelope efficiency or installing efficient devices, and these devices were often above the EPCA federally required standard. The court noted that installing more efficient devices than the federal standards was actually cheaper from a compliance standpoint than the alternatives. And so the court, this was actually the Ninth Circuit, found that there was an economic incentive to adopt products that were above EPCA standards, but this was not a requirement. So there was no penalty or legal compulsion then to use products that was more efficient than EPCA. And the court distinguished this situation from Albuquerque, where it was more expensive, the court had found, to install the federally compliant products along with other required building upgrades. We've also talked a little bit about the Berkeley case, and Berkeley was an EPCA general preemption case, but it was talking about whether or not EPCA applied at all to upstream regulation of gas, as opposed to the direct regulation of products. So there was not an argument about whether this met the 7-factor building code test. And in fact, the court noted that the parties agreed essentially that because there was not alternative compliance, it wouldn't qualify for the 7-part building code test. So the question was just, does EPCA apply in this type of scenario? And it should be mentioned as well that the court's finding, which my colleagues discussed, only applies in the Ninth Circuit right now. So if a jurisdiction is going to go forward with an all-electric building code, or certainly limiting the gas connections for new construction as Berkeley did, then this is foreclosed in the Ninth Circuit, pending the potential for an appeal that Dani mentioned. So to summarize where we're at from building code perspective and federal preemption, if you are going to be using a building code to incentivize products that are electric or products that are above federal standards, then you must leave enough flexibility with other performance-based options to not trigger preemption. So we don't have a lot of case law to look at this stage, although there may be more coming with the local action and state action that's in this space. But what we do know is that if a court views the building code as penalizing the use of EPCA compliant natural gas products, then that is more likely to be preempted. And if there's an incentivizing the use of electric products, that's more likely to be okay. In terms of the Berkeley case and how this fits in, as mentioned, this was not trying to do the 7-factor test, but if you had a building code that was going to be requiring all electric or restricting the use of gas, that is still okay outside of the Ninth Circuit. We don't have a ruling outside of the Ninth Circuit that would restrict the ability for local jurisdictions to do that. And both the district court and the Department of Energy would have found that the Berkeley approach was not preempted by EPCA. They found that it was, they were arguing, and the district court found that regulating upstream essentially was not a regulation of the product itself. So that may mean that another court would reach a different conclusion from the Ninth Circuit. So we've given you a lot of information. Hopefully this was helpful, but we don't expect that you would necessarily know all of the answers. And so we're here to help. And if there is follow-up that folks would like us to do for you, this is our Public Health Law Center contact information. And now I think we're going to move over to Q&A.
Thank you, Jamie. Well, thank you, Jamie. Thank you, Daniel. And thank you, Dani, for your great presentation today. Before we get right into the Q&A, we've got a couple more poll questions to ask you guys. It just prompted on the screen is we want to get an understanding of what do you see as the main barriers for implementing equitable building performance and decarbonization efforts in your state or your local government. So take another five seconds to answer that, and we'll take a look at those results and help inform the conversation that we're having today. And I see a question in the chat about including contact information. We will definitely make sure to send contact information for both the IMT folks as well as PHLC to all of our registrants today. Let's go ahead and see the results from that poll. So it looks like overwhelmingly there is almost of a tie of fear of unintended consequences and the resources for local authority to implement policy. I'm glad we touched on that, or I'm glad that one is such a strong response, because we will be able to actually talk a little bit about like what those resources for local authority can be in order to implement policy. One thing I do want to stress to our audience today is that as you can see from our slides today, so PHLC, Public Health Law Center, is a partner at IMT, but they're also partners for, like Dani said, for a lot of communities, advocates, and local governments. So they can speak much more impactfully and thoughtfully, as they've done today, on the legal approaches that governments and advocates can take going forward. And one of the things that we want to also make sure is the questions that we are talking about today are only just a snapshot of what PHLC can also speak to further and more detailed outside of this webinar, and we'll make sure that you guys get their contact information going forward. So let's go ahead and transition to our Q&A. We've already got a couple poll question, or we've already got a couple questions that have come up during the chat. This first one, I am going to kick it over to Dani, and it was someone who's mentioned they'd like to hear a little bit more about local authority to enact some of these policies. My understanding is that nitrous oxide emissions may only be regulated at the regional or state level. In addition, California Public Utilities Commission's obligation to serve requirements seems to stand in the way of decommissioning. Dani, I'll toss it to you.
Yeah, so unfortunately, my answer to this is going to be that it really varies depending on which state that you're in and what the state law legal landscape looks like around each particular pollutant. Nitrogen dioxide would be under the state implementation plan. And so the level, you're going to have to look at the SIP and potentially work with state officials in trying to get some flexibility as to how to regulate emissions, at least from the types of sources that the Clean Air Act covers. So that, you know, not every single source, but then you run into, if you're looking at appliances, then you run into EPCA. So it's kind of a tangled web of authority. As far as the as far as the duty to serve, that is a quickly advancing area of law, and so I think the legal interpretation as to how far that duty extends is a little bit up in the air right now, but it's definitely something that is going to be litigated if we see if we can take any indication from how the gas industry has been handling Berkeley's ordinance. So unfortunately, I see that Daniel's off mute. I'll let him hop in. I'm sorry that I don't have a more concrete answer for that one.
I totally agree with your answer. I think it's a space of a lot of unknowns, because we haven't really waded into the question of the obligation to serve for utilities from the perspective of transitioning away from gas entirely. It's for folks who don't know, the obligation to serve is something that's generally thought of as a requirement for any customer within the service area of the utility, requirement for the utility to serve the customers within their service areas as a general matter. There's a lot of, I don't want to say exceptions, but it's sort of a balancing test in the sense that when it is extremely expensive to serve, and this varies from state to state, but at least in some states, when it's extremely expensive to serve a customer with their desired utility and an equivalent can be achieved, for example, as if it's very expensive to build out a gas pipeline to like a single building in a rural area, and the equivalent service can be achieved through electrification that, you know, say power lines already run out there, then it's generally, even now, not considered within the scope of the obligation to serve, or it's considered maybe an exception or a case where the obligation to serve can be overcome by the cost. But I totally agree with Dani. the question is now, what if we say that there's actually a public interest in reducing the service areas of these places? And on top of that, what can be done? Because these are state level doctrines, they're going to vary from state to state. And in addition to that, they can be modified by the state legislature, potentially even the state public utilities commissions. And then a final just like thought on this that's been bouncing around sort of mostly academic spaces is, what if the service areas of utilities themselves are reduced? So a state PUC can simply say that you don't have, this gas utility does not have authority to serve in this area, and therefore has, theoretically should have no obligation to serve. So that's just another way of reimagining the obligation or the duty to serve within the context of a general economy-wide transition.
Thanks, Dani. Thanks, Daniel. Looks like we've got a question related to local privacy laws. So has anyone faced challenges around local privacy laws, especially in buildings with few meters? I believe we had an initial answer to this in the chat, but I'm going to, is there anyone from our PHLC colleagues that would like to take a first stab at this?
I can just note that there are ways to structure policies to protect privacy. So jurisdictions, when they're dealing with an individually metered building, you can anonymize the data, you can group data with several buildings at once, or look at the size of the building and set certain parameters around that. So there are policy design ways to help protect privacy.
And for a lot of jurisdictions that have, so again, I'm based in St. Louis, Missouri. We have a benchmarking law and a BPS policy. And one of the things that was created during the benchmarking law was that there was specific language about making sure that local utilities can require that anonymized data that Jamie mentioned. It's of particular interest also and helpful for the building owners of affordable housing and multifamily and mixed use buildings, so they can obtain that data in order to, one, comply with the law, but also have a way for them to obtain that data and also have a better understanding of what that looks like, as well as providing it in a manner in which still protects the tenant's right to privacy. All right, our next question is, does Ithaca's green building policy apply to existing buildings at this time? Now, Dani covered Ithaca's policy in her initial suite of slides, but their green building law applies currently to new construction and major renovations. So it covers some existing buildings, but it does not cover all large existing buildings. And also another thing to point out is that Ithaca is a member of the National BPS Coalition. A lot of the jurisdictions that our presenters today have talked about are within the National BPS Coalition, which is an initiative launched last year by the White House to help jurisdictions either help develop a BPS policy, and this is where partners like PHLC can help provide those legal pathways towards policy adoption, or two, they're currently in implementation right now, and how to, again, move forward on implementation given preemption concerns and some of the other concerns that we're seeing popping up on a national level. Looks like we've got another question here talking about which states have the strictest decarb regs for commercial real estate investors, and which will have the least. I will be honest, I'm not adept enough on understanding which ones have the strictest decarb regulations. I'm not sure if any of our PHLC colleagues have something to offer here, but that is something that we could sort of follow up. But before I move on, I'm not seeing a shaking of a head from our PHLC folks, but I will make sure that we follow up specifically on that question for you, Angela, so we can get you a proper response.
I just recommend taking a look at Washington State and Colorado as two states that have done really good things on the new commercial construction.
And I don't want to make sure, I don't want to, there was an early on question, I believe, about local law 38 in New York. Dani, I saw you shaking your head. Do you want to maybe address that question?
I'm trying to track it down right now, so give me a minute and I'll post it in the chat, unless Daniel knows.
It was, can you speak to local law 38 and how it potentially impacts wood fire pizza restaurants in New York?
Yeah, I mean, I'm trying to track down the answer, not the question.
Sorry. I believe wood burning is exempt when it is for specific cooking type like charbroiling. But again, if we don't have a well-informed response, we'll make sure to follow up with that one with Justin, who posed that question in the Q&A. All right, let's see. We'll take about maybe one or two more questions, and then I will close us out for the conclusion of this webinar.
Looks like there's one in the Q&A on takings that I'm happy to address.
Go for it, Jamie.
Okay, so Mark is asking about whether there is a risk for any of these policy options based on takings law. And I can just briefly indicate that takings law should not be a challenge for implementing these policies. So takings, for those who aren't familiar, is a constitutional protection against the seizure of property without just compensation. And generally, it requires there to be a full economic taking. So that would mean that you essentially can't use your property anymore. And so if you're limiting gas, for example, which is the through line for most of what we've talked about, that's not going to rise to the level where you can't use the property for another economic activity. So for example, if you're a restaurant and you're prevented from using gas, you can still make money as a restaurant by cooking with electric.
Thank you, Jamie. I think we will close out with one more question. I'm actually going to point to Ted Tiffany's question. What advice would you give local jurisdictions while we're waiting for courts to finish the Berkeley decision? Amend, repeal, or add to policies? This is there isn't a straightforward answer to this question, so I will say that to start, Ted, but looks like Daniel, you were about to say something. Go ahead.
Yeah, I can answer a slightly different question, which is what is the outlook? What is the next steps for the Berkeley case? It's so right now for folks. So as I mentioned, the Berkeley case is expanding the arguably expanding the scope of EPCA preemption, or reading the scope of EPCA preemption more expansively. It was a panel decision of the Ninth Circuit, meaning it was made by 3 judges, and there's a petition for it to be heard by a larger group of 11 judges at the Ninth Circuit, the same level. That was filed in late May, and the court just last week directed a response to the petition. So I believe in mid-July, we'll have the response to that. And then there's a whole process that's internal to the Ninth Circuit. But the question of whether or not the Ninth Circuit is going to rehear it, which would withdraw the decision, at least make it uncitable, which essentially withdraws it from use in litigation, is going to be answered within the next few months. And so that question, at the very least, is a short-term one, and something where I think that any local government process that's that's looking at options, or that's in the development stage, that's not like writing an ordinance or enacting an ordinance right now, I think can afford to continue as this process moves forward. And yeah, so I'll leave that there unless other panelists want to talk more about it.
I think that is a good question to end on. Thank you for that response, Daniel. We're going to close out with one final poll question that just popped up on your screen, and that's getting a better understanding of your legal support. What area of your work would you welcome legal support? So whether that's on developing a BPS policy and its enforcement, understanding authority to regulate health standards, or understanding the authority to regulate cost pass-throughs and tenants' rights. These are just some examples. There's obviously a whole myriad of areas in which a jurisdiction could welcome legal support, but take another 5-10 seconds to answer this, and we'll go over those poll results and talk about our next steps after today's webinar. And while those results are being tallied up right now, again, I do want to say a big thank you to Jamie, to Daniel, and to Dani today from the Public Health Law Center for their presentation today. We will share out the contact information for both the IMT folks as well as our PHLC colleagues, so we can have follow-up. And it looks like overwhelmingly the area of legal support in which people would welcome is on developing a BPS policy. So again, there is the National BPS Coalition in which the White House launched last year. One of the roles that IMT plays within that coalition is that we help staff the jurisdictions in the coalition and help provide supplementary research and technical assistance and support to those jurisdictions outside of what the Department of Energy, the White House, and the EPA is offering. Later this year, the federal government will be unrolling a federal BPS technical assistance network, and they are also working with a national coordinating entity called